Welcome to the deep dive. Today, we're trying to untangle a really remarkable and frankly quite puzzling legal story. It kicks off with the 2014 redundancy of some former officers at RBC Royal Bank, that's the TNT branch, Trinidad and Tobago Ltd.
Right.
And what came next was this case, special tribunal case, ST006 of 2015, that, well, it just wound its way through almost every single level of the legal system.
It really did. Quite a journey.
Yeah. We've got a formal statement here, and it outlines what it claims are some, pretty serious legal flaws in how that all unfolded.
And that statement is our main source for this discussion.
Exactly. So our goal, really, is to get to the heart of it. What actually happened? Who are the main players involved here? Where did things maybe go off track?
And crucially, why does this source argue that the special tribunal itself isn't actually at fault in this whole intricate process?
Right. So if you've ever found yourself scratching your head trying to follow a complex legal case without getting totally bogged down in jargon, well, hopefully this deep dive will bring some clarity.
What's really interesting about this one, as you said, is that journey all the way up to the Privy Council. It really shows how something starting as a redundancy issue could spiral into something incredibly complex.
Yeah.
And the source material doesn't just give us a timeline, it really points fingers, It's specific missteps and the impact they supposedly had.
Okay, so let's start right at the beginning then. 2014, those redundancies. Former estate constables at RBC Royal Bank TNT Ltd. were let go because of restructuring.
Standard procedure in some ways, but what followed wasn't.
No, because here's an interesting point early on. 14 of these officers, they decided they wanted to handle things themselves. They each apparently put up $1,000 to hire an industrial relations officer, a Mr. Harrison Thompson, specifically to represent them privately at the industrial court.
Right, privately. That's key.
Yes, their intention was really clear. They wanted to act independently, not, through the Estate Police Association, the EPA.
And that desire for independent action, it seems like it's a really crucial thread to follow here. That choice to go outside the usual union structure really set the stage for a lot of the later problems.
It really did. Because here's the first, kind of twist. Despite these officers clearly wanting private representation, paying for it, agreeing with Mr. Thompson, the actual legal dispute that got filed, ST006 of 2015, it was submitted under the EPA's name.
Oh, okay.
And this apparently happened without the consent or knowledge or even the approval of those initial 14 officers who had paid for their own guy.
Wow.
Our source calls this a procedural hijack.
Okay, procedural hijack. That's strong language. So what does that mean, practically? Filing under the EPA when they hadn't explicitly asked for it.
Well, that's the question, isn't it?
Right. It immediately changes who's in the driver's seat, legally speaking. The EPA becomes the claimant, acting for its members, even though these specific members wanted something else.
Exactly. So who really had the authority? Were there individual interests being represented? Big questions there. And then it gets even more tangled. There's this police officer, Mr. Robert Rematar, who comes in as an intermediary.
Okay.
He apparently presented Mr. Thompson as this, super successful guy, claimed he'd never lost a case.
The classic sales pitch. Creates expectations.
Totally. And Mr. Rematar, he collected those $1,000 fees from the 14 officers, but, and this is a big red flag, apparently no receipts were given, no accounting ever provided.
Oof, not good.
And he also controlled the communication, acting as the go-between for Mr. Thompson and the officers. That lack of direct contact and transparency feels, immediately problematic.
It absolutely does. No financial records, controlling communication.
Yeah.
It just creates this distance, doesn't it?
Yeah.
Hard for the clients to know what's really going on or, exercise their rights.
And it didn't stop there. The scope of the claim just balloons.
How so?
Well, the names of all 42 officers, not just the 14 who paid, were submitted to the Ministry of Labor as part of this dispute.
All 42, without their consent.
Again, apparently without consent. And the source says some of these people didn't even know their personal data was being used in this legal filing.
That sounds like a massive overreach. Using people's data like that without permission, that raises some serious ethical, maybe even legal alarms.
You'd think so. Then there's another fundamental issue, how the case was even, classified.
What do you mean?
The termination letters the officers got, they clearly said redundancy. That was the reason given by RBC.
Okay, redundancy.
But the legal case, it was filed as a dismissal case.
Ah. Okay, for someone not deep in labor law, why is that distinction so important?
Well, you tell me. Doesn't the Industrial Relations Act treat them differently?
It absolutely does.
Yeah.
Redundancy and dismissal, they have different legal tests, different procedures, different potential outcomes, different remedies. Filing it under the wrong category right from the start, it could just completely undermine the whole claim.
Right.
It's like you said earlier, trying to fit a square peg in a round hole. The legal framework just isn't set up for that situation if you mislabel it.
And adding to this procedural mess, there seem to be 2 different registration dates floating around for this case.
Seriously?
Yeah. Court documents apparently show September 2nd, 2014, but the EPA had a record saying 7th, 2014.
Huh. Why would there be a discrepancy like that on something so basic? A registration date.
Exactly. It suggests, maybe a lack of precision or worse in the foundational paperwork.
Yeah, discrepancies in key dates. That just casts doubt on the reliability of the whole record, doesn't it? Hints at administrative errors, maybe inconsistent record keeping. Not good in a legal context.
And one final point on these initial missteps, maybe? The Certificate of Unresolved Dispute.
Okay, yeah, that's crucial. Issued by the Ministry of Labor after conciliation failed.
Yeah.
You needed to go to the tribunal.
Right. And the Industrial Relations Act, the IRA, it says this certificate has to be issued within 14 days of conciliation ending. 14 days.
Okay, a clear deadline.
In this case. It was issued over 200 days later.
200, not 14.
Over 200. And our source states pretty bluntly that this massive delay actually voided the referral to the tribunal. Like, it stripped the tribunal of any lawful authority to even hear the case.
Wow. That's a critical procedural failure. Those statutory timelines, they're not just suggestions. A delay that huge.
Yeah.
Yeah, I could see how that could invalidate the whole referral. It's like missing a court filing deadline. The whole thing could just fall apart.
So with all these huge issues right from the get-go, the wrong representation, maybe the expanded list of claimants without consent, the wrong legal issue being argued, conflicting dates, that incredibly late certificate, the case still lands before the special tribunal.
Despite all that baggage.
Yep. And what's interesting is, at the very first hearing, the chairman of the tribunal apparently told the EPA, go back and negotiate with the bank. Suggested it wasn't really suitable for a hearing at that point.
So the tribunal itself flagged it early on.
Seems like it. And it's noted that Mr. Thompson later admitted he and Mr. Rongmatar did try to negotiate after that instruction. So that initial reaction from the tribunal, it feels telling. Like maybe they saw some of these underlying problems.
That could definitely be read that way. The tribunal may be seeing the weaknesses or the irregularities in how the case was brought forward, suggesting a less formal resolution first, a cautious approach.
But negotiation didn't resolve it, obviously, because on January 31st, 2018, the special tribunal gave its ruling. And it was crystal clear, quote, "We rule that we have no jurisdiction in this matter, and it is hereby dismissed."
Okay. Dismissed based on jurisdiction.
Exactly. And this is absolutely vital to understand, right? The dismissal was because they felt they lacked jurisdiction. It wasn't a ruling on whether the officers actually had a valid claim about the redundancies themselves.
Precisely. The tribunal wasn't saying your redundancy claim is wrong. They were saying, because of these procedural flaws, very likely that super late certificate, we don't have the legal power, the authority to hear this case.
Right. That distinction is so important if we're trying to figure out why the tribunal isn't being blamed here.
Absolutely key.
And then here's another really strange element mentioned in the source.
Oh, well.
It mentions an observation of a second hearing, allegedly held June 21st, 2018, with the same parties.
A second hearing after the dismissal.
Yeah. But this supposed hearing isn't recorded in any public or court documents. The industrial court apparently hasn't provided any info about it.
An undocumented hearing. That definitely raises questions about transparency and, proper procedure. Very odd.
Very odd indeed. Now, to really nail down why the special tribunal isn't seen as responsible here, we need to talk about its legal standing. Our source is clear. It's an inferior statutory tribunal. What does that mean in practice?
It basically means it's a body created by a specific law, a statute, right? And its powers, its authority are strictly limited to what that law says it can do.
So not like higher courts with broader powers.
Exactly. Unlike, say, the High Court, which has inherent jurisdiction, these tribunals can only operate within the specific lines drawn by their enabling legislation.
Yeah.
They can't just decide to hear anything.
Okay. And crucially, once the special tribunal issued that dismissal ruling, it became, what's the legal term? Functus officio.
Right, functus officio.
For listeners maybe not familiar with Latin legal terms, what does that signify here?
It essentially means having performed its office or task completed. Once the tribunal made its decision, the dismissal for lack of jurisdiction, its job, its function regarding that specific matter at that stage was done.
So it couldn't do anything else on that case.
Pretty much. It had no further legal power or authority to take more action on that specific matter. It couldn't revisit its decision. It couldn't initiate an appeal. As far as the tribunal was concerned, the case was closed because they didn't have the jurisdiction to open it in the first place.
Okay. But despite this dismissal, despite the tribunal being functus officio, the legal fight, well, it kept going.
It did.
The EPA, they sought judicial review in the High Court. This was between April and June 2019.
Right, trying to challenge the tribunal's decision.
Yeah. But Justice Rampersad dismissed it. He agreed with the tribunal, finding it didn't have jurisdiction. So at this point, you've got the special tribunal and the High Court on the same page.
Yes, that High Court decision seemed to back up the tribunal's original ruling.
Yeah.
Suggesting maybe that the real issue wasn't the tribunal's conclusion, but the reasons for the lack of jurisdiction, those earlier procedural problems.
But then we get to this affidavit submitted by a Mr. Clay Hackett supporting that judicial review.
Okay.
And according to our source, this is where a lot of misleading information allegedly entered the record.
How so? What did it claim?
Well, the source says the affidavit relied on hearsay from Mr. Thompson. It didn't mention the tribunal's instruction to negotiate.
Omitted that bit. Okay.
Continued to push a version of events that was apparently contradicted by evidence later on, presented an inaccurate timeline, and again included the private data of all 42 officers.
Wow. And what's really concerning, the source claims, is that even after Mr. Hackett supposedly got the verbatim transcript, the actual word-for-word record, which proved his affidavit wrong on points, he didn't correct it. That's a very serious allegation. Putting false or misleading info in a sworn affidavit is a huge deal in court. Affidavits are supposed to be the truth, the whole truth.
Right.
And not correcting it when presented with contradictory evidence, that's particularly troubling if true. It could really mislead the court.
Indeed. Because the story takes another turn. The Court of Appeal gets involved. July 2019 to July 2021.
And what did they decide?
They actually overturned the High Court. They found the tribunal's dismissal was wrong in law and sent the whole thing back to the tribunal for a full hearing on the merits.
Oh, okay, so now you have a direct conflict. The Court of Appeal disagrees with both the High Court and the Special Tribunal about that initial jurisdictional dismissal.
Exactly, a clear disagreement between judicial levels.
The Court of Appeal sending it back suggests they had a different legal interpretation. Maybe they felt the tribunal should have heard the case on its merits, despite those procedural issues that led to the jurisdictional ruling. Just shows how complex these things can get, different legal minds seeing it differently.
And this disagreement, this Court of Appeal ruling, it sets the stage for the latest development, according to our source.
Which is?
The special tribunal itself is appealing to the Privy Council.
The tribunal is appealing.
Yes. Their goal is to get the Privy Council to overturn the Court of Appeal's ruling and basically reinstate their original dismissal, the one based on lack of jurisdiction.
Okay, wow. The tribunal appealing to the highest court. That really underlines their conviction, doesn't it? That they were right the first time, that they truly lack the authority to hear the case because of those earlier flaws. They're essentially arguing the Court of Appeal made a mistake sending it back. Okay, wow. The tribunal appealing to the highest court. That really underlines their conviction, doesn't it? That they were right the first time, that they truly lack the authority to hear the case because of those earlier flaws. They're essentially arguing the Court of Appeal made a mistake sending it back.
So let's circle back to that core question. Why is the special tribunal, according to this source, not to blame for this incredibly long, drawn-out legal battle?
Right, let's break that down based on the source's arguments.
Okay, first, as we discussed, that statutory limitation, Section 59 of the IRA. The tribunal's power comes only from the minister's referrals. It can't go beyond that scope.
Exactly. Its jurisdiction isn't inherent. It's granted and limited by the law that created it and the specific referral it receives. Can't just take on any case.
Second, that crucial concept, functus officio. Once they dismissed it, their legal role was finished for that stage. They simply didn't have the power to initiate or even join in the subsequent appeals started by others.
Right. That principle of finality at each level is key for things to work properly. Otherwise, cases could just bounce around forever at the same stage.
Third, the idea of who can appeal. Constitutional jurisdiction, only parties who are aggrieved by a decision can appeal it.
And the tribunal, being the neutral decision maker, isn't aggrieved by his own ruling, right? It doesn't have a side in the fight.
Precisely. Its role is to judge, not to have a personal stake in the outcome that would give it the right to challenge its own decisions.
Makes sense.
And finally, our source points to established legal precedent, previous court decisions. These apparently confirm that tribunals like this are inferior statutory bodies. They don't automatically get appeal rights unless a law specifically gives it to them.
And it seems no law did, in this situation, regarding their own jurisdictional rulings. So precedent backs up the idea that they couldn't appeal or be forced back into it inappropriately.
Right. So based on all that, the source argues the tribunal acted correctly within its limited powers.
Okay, so if the tribunal isn't to blame for this mess continuing for so long, who was responsible, according to the source?
Well, the source clearly points to several parties. It argues they played roles in prolonging what it sees as an unlawful continuation of the whole thing.
Right, who's on the list?
First up, Mr. Harrison Thompson, cited for allegedly taking private funds from those 14 officers, but then filing the case under the EPA's name without their authority.
That initial move, the source argues, kind of set off the whole chain reaction of problems, that mismatch between what the individuals wanted and how the case was filed.
Yeah, seems foundational. Then the State Police Association, the EPA itself.
Okay, what's their alleged role?
For filing without the consent of those 14 officers who wanted to go private, and also for apparently not following the tribunal's initial suggestion to go back and negotiate with the bank.
So acting without a clear mandate from everyone involved, and maybe ignoring guidance that could have resolved it earlier.
That's the claim. Then the Solicitor General's legal team and the state attorneys, they also come under scrutiny.
Government lawyers. Why?
For initiating or supporting appeals, the source claims, without lawful instruction, and for allegedly misrepresenting why the tribunal dismissed the case, attributing it to a branch board, which wasn't the reason given.
Misstating the grounds for dismissal.
And just for continuing the litigation, despite that initial jurisdictional dismissal by the tribunal.
Okay, so questions about the legal basis for the state pursuing those appeals and whether they fully understood or represented the tribunal's actual reasoning.
Seems to be the point raised. And finally, the Ministry of Labor.
Back to the beginning, with the certificate.
Exactly. Called out for issuing that crucial certificate of unresolved dispute so incredibly late, over 200 days past the deadline. The source argues this created a fundamentally defective referral, which was the root cause of the tribunal lacking jurisdiction.
So that delay is seen as the critical underlying procedural failure that arguably kicked off the whole jurisdictional problem.
Right. So if you put it all together, the picture painted by our source is wrong parties starting a case the wrong way, arguing the wrong legal issue based on a legally flawed referral because of that late certificate, and then a series of appeals and actions followed, allegedly based on misrepresentations or without proper authority, after the special tribunal had already correctly ruled it couldn't hear the case due to those initial flaws.
So the conclusion is pretty stark. The tribunal did its job within its legal limits, and the responsibility for the drawn-out battle lies with these other identified parties and their actions or inactions.
That's the essence of it. It paints a picture of a case that was, maybe flawed right from the start because of these procedural errors and questionable actions. And this led to this long, complicated legal fight that the source argues really shouldn't have gone past that first dismissal by the special tribunal.
It really does highlight how vital it is to follow procedures correctly from day one. Get those foundational steps wrong, and the potential for huge, lengthy complications just skyrockets.
Exactly. So the key takeaway isn't about the tribunal making a mistake. It seems to be a story about how those initial procedural failures, combined with subsequent actions by others, may be based on misunderstandings, maybe misrepresentations just cascaded, leading to years of complex litigation following what the source presents as a legally sound jurisdictional dismissal.
A real cautionary tale about process, it seems.
It really makes you think, doesn't it? How can these kinds of breakdowns, these initial procedural slips or unauthorized actions, ripple so dramatically through our legal systems, leading to years of complex, expensive litigation?
Yeah.
What kind of safeguards could